Hello students, in this class we are going to talk about the concept of territory under international law. So as you know, international law is based on the concept of state, and as we have seen in the subjects of international law, the principal subjects of international law are states. International law applies to states principally. So the concept of territory is important to the concept of state, just like the concept of sovereignty is important to the concept of state. So the concept of state in turn is based on the concept of sovereignty. That state would not be a state if it was not sovereign. The very idea of a state is based on the concept of sovereignty. And how will sovereignty be exercised if there is no territory? So that's how the concept of state and territory are intrinsically linked. You cannot imagine a true state in international law without sovereignty, and then you cannot exercise sovereignty if you do not have territory. So also you have seen the Montevideo Convention article 1 says that territory is one of the important elements of statehood. So that's how the concept of a state is intrinsically linked with the concept of sovereignty, which in turn is linked with the concept of territory. So this is the class in which we are going to talk about territory in international law, and what are the different aspects of territory, how territory is acquired in international law, what are the different types of territories, and international law concerning those different types of territories. Now, when we talk about territory, first thing that we should understand is that there are different types of territory, in the sense that there are territories over which no one has occupation. It's non-occupied territory. No sovereign has a control over that territory, though it may be rare to find in these days where there's territory where no one is occupying it and no one has sovereignty. In the earlier times, perhaps when the land was still being discovered, there was this question of non-occupied territory. Now it's extremely rare, but then there is, first of all, we have to understand that there is this kind of territory, which is a territory which is not already subject to any sovereignty. It's unoccupied territory. That is the first kind of territory. What can be the other types of territory? Other type of territory can be a territory which is not subject to any sovereignty, which is non-occupied, unoccupied territory. Now, second type of territory can be a territory which is already subject to sovereignty, means some state already has sovereignty over that territory. So that is another territory. And the third is a territory over which, even though no one has sovereignty, but it's common, it's a common heritage. All states are allowed or entitled to access that as a common heritage. It's a common heritage of mankind. It's not capable of being subject to sovereignty. So there are three types: territory which is already subject to sovereignty, which is an occupied territory; territory which is not subject to any sovereign, right? That's also called terra nullius. And then there is territory which is, or which cannot be subject to any sovereignty because it's common, it's shared in common, it's a common heritage of mankind, like outer space or open seas. So this is called, the common heritage is also called res communis. So I hope you understand this. What is a territory which is already occupied, territory which is unoccupied, that is also known as terra nullius, and then territory which is a common heritage, means everyone can use it equally. For example, the outer space and open seas. Open seas cannot be subject to any sovereignty, just like the outer space. So occupied territory, terra nullius, which is non-occupied territory, which is not subject to any sovereignty, and then res communis, that is common heritage. Since this class is about territory and this class is primarily about territorial sovereignty, let's see how territorial sovereignty was defined in international law. And one of the more accepted definitions was given by Max Huber in the Island of Palmas case in 1928, that's PCIG case. I'll read a passage from the judgment. Max Weber writes, sovereignty in relation to a portion of the surface of the globe is the legal condition necessary for inclusion of such portion in the territory of any particular state. Sovereignty in relation to territory is present a word called territorial sovereignty. Further, sovereignty in relation with state signifies independent. Independence in regard to a portion of the globe is the right to exercise therein to the exclusion of other states, the function for state. So, sovereignty in regard to a territory is what? What is the meaning of sovereignty in regard to a territory? Means independence or exclusion of other states' right in that particular territory in carrying out the functions of the state. Right? So, that's how territorial sovereignty was defined by Max Weber in this case. Next thing that we have to understand is how a territory can be acquired. What are the different modes of acquisition of territory? What are the ways in which a state can acquire a territory? And there are different ways in which states can acquire territory, and some of the popular modes of acquisition of territory are: first, occupation of the territory; second, annexation of the territory; third, accretion of the territory; fourth, prescription; fifth, cessation; sixth is a territory can be acquired by entering into treaties. And then there are other modes of acquisition like ex eque bono, where equitably some territory is granted to a state in an adjudication, or there is some border disputes, and as a resolution of that border dispute, a treaty goes to some other state. So we'll see some other modes of acquisition of territory, but these are the classical modes of acquisition of territory: occupation, annexation, accretion, prescription, cessation, and by entering into treaties. So let's try to understand each one of them one by one. What do they mean? What is the meaning of occupation? Because occupation in a day-to-day language may mean that you go and occupy something, but then technically speaking, legally speaking, when can we say that a occupation is a valid occupation? Let us look at occupation first. Occupation means what? What is the meaning of occupation? Occupation means establishing sovereignty over a newly discovered or abandoned territory. In other words, previously unoccupied territory. So, occupation means that when a state establishes sovereignty over a territory which at that time was not under sovereignty of another state, then only it is called occupation. Basically means the territory should be terra nullius, means the territory has not been occupied by any other state at that time, or either if it was occupied, it should have been abandoned, which is a rare scenario, though still basically territory should be terra nullius, means it should not be subject to any other sovereignty at the time of occupation. So acquisition by a state of sovereignty over a territory which is at the time not under that sovereignty of another state is called occupation. And there are two main requirements of an occupation under international law. First is, as you've seen in the definition itself, that the territory must be terra nullius, means that should not have been occupied by any other state. Second, that there must be an effective occupation. So there are two requirements. First is territory must be terra nullius, and second, that the occupation must be an effective occupation. To understand the concept of terra nullius, let us look at the 1975 ICJ advisory opinion on the Western Sahara case. Now, I'll not go into the details of this case because there are many details in this case which are not relevant to the topic at hand. The topic at hand which we are dealing with now is terra nullius, and there's this one question in this case which speaks about that, and that's the question that we are concerned with. So the ICJ was asked to give an advisory opinion over certain questions in the Western Sahara case. And one of the important questions in this case was the colonization by Spain of Western Sahara. And this is the exact question, as you can see here. Was the Western Sahara at the time of colonization by Spain a territory belonging to no one? So when Spain colonized Western Sahara, was it a terra nullius at that time? So was that a territory which belonged to no one at the time when Spain colonized Western Sahara? This is one of the question which the court was asked to give its opinion on. Now let's turn to page 39 of this case and try to find out what the court ruled in this case. So here is the relevant part of the judgment. Paragraph 79. Turning to question 1, the court observes that the request specifically locates the question in context of the time of colonization by Spain and therefore seems clear in words, was Western Sahara a territory belonging to no one, have to be interpreted by reference to the law in force in that period. The expression terra nullius was a legal term of art employed in connection with occupation as one of accepted legal methods of acquiring sovereignty over territory. So this terra nullius court is saying is important in order to ascertain occupation over a territory. Occupation being legally an original means of peaceably acquiring sovereignty over territory otherwise than by cessation or succession, it was cardinal condition of a valid occupation that territory should be terra nullius, that is, a territory belonging to no one, at the time of the act alleged to constitute the occupation. So it is saying it is one of the few means of acquiring a territory, peaceably acquiring a sovereignty over a territory. And in order for an occupation to be a valid occupation, the territory should be terra nullius, means at the time of occupation, the territory must be belonging to no one, and that's the main question, and that's the main rule that was established in another case, which is the legal status of Eastern Greenland case, which is decided by the PCIJ. So the court is recalling the Eastern Greenland case here again, and it is telling that expression terra nullius basically means that territory is not occupied by anyone, and for occupation to be a legal occupation, it should be the case that the territory is terra nullius. Now whether this was the case in Western Sahara case, in view therefore, let's read ahead. In view therefore, a determination that Western Sahara was a terra nullius at the time of colonization by Spain would be possible only if it were established that at the time territory belonged to no one in the sense that it was open to acquisition through the legal process of occupation. So this is the question that the court wants to answer. So the court in this case finds out that in the present case, the information furnished to the court shows that at the time of colonization, Western Sahara was inhabited by peoples which, if nomadic, were socially and politically organized in tribes and under chiefs competent to represent them. It was also shown that in colonizing Western Sahara, Spain did not proceed on the basis that it was establishing its sovereignty over terra nullius. It's saying that the territory was already being inhabited by tribes, and the tribes have had some kind of political organization. So you cannot say that the territory was terra nullius at the time of occupation. So then the court, on the basis of this, went on to say that the occupation of this territory was not legal because it was not terra nullius, right? So that's the basic understanding of what is the meaning of terra nullius, which is an important requirement when it comes to occupation. In brief, terra nullius is a land which belongs to no one and there is no political activities at the time of occupation, and the territory could either not belong to anyone or it can be abandoned by a previous sovereign. However, in the Western Sahara case, it was found that before or at the time Spain colonized Western Sahara, there were some tribes which were already inhabiting the area, and there were politically organized tribes, and there was a tribal chief who was representing them. For this reason, the territory was not terra nullius, so the Spanish occupation of Western Sahara was not a valid occupation. So that is the first element of occupation, that territory must not be occupied, or the territory must be terra nullius. The second requirement is that there must be an effective occupation. Now, what is the meaning of effective occupation? This second requirement in turn has two sub elements. So in effective, what is the meaning of effective occupation? That has two sub elements which were explained in the Eastern Greenland case. Eastern Greenland case was a dispute between Norway and Denmark over the territory of Eastern Greenland. In that case, these two further elements of effective occupation were explained. Let us read a paraphrase of the adjudication of the Eastern Greenland case. In the Eastern Greenland case, the Permanent Court of International Justice laid down that occupation to be effective requires on the part of appropriating states two elements. And first, an intention or will to act as sovereign, and second, the adequate exercise or display of sovereignty. So first is the intention to act as a sovereign, and second is adequate exercise or display of sovereignty. So these are the two elements which were further elaborated, sub elements so to speak, about the effective occupation. Now let's try to understand them. First one speaks about intention of a sovereign to act, intention to act as a sovereign, and that is simple enough, that can be understood by the functions that the sovereign carries out in the occupied land, whether it intends to act as a sovereign or whether it intends to just come there and do trade. So for example, when East India Company initially came to India, its functions were limited to trade, but when they started passing some regulations, orders, laws, and when they started controlling the territory exclusively and excluding the Indian rulers from controlling those territories, then that particular occupation then become an intention to act as a sovereign, because they wanted to be the sovereign over that territory. So that is the first thing, intention to act as a sovereign, which can be understood by the way that activities are carried out. The second is adequate exercise or display of sovereignty, and that can be satisfied by showing the possession and control of the territory and the physical assumption of the territory. So in the Minkiers and Acros case, the ICJ said that the actual exercise of state functions, that is local administration, local jurisdiction, acts of legislative authority, can be shown to prove that there is a continuous display of sovereignty. So the second element, which talks about peaceful and continuous exercise of sovereignty, can be determined by seeing actual exercise of state functions such as local administration, judicial, legislative authorities. Now, again, in Island of Palmas arbitration, which was a dispute on the title of the Island of Palmas between the United States and the Netherlands, the court observed that mere the act of discovery by one state of a territory is not enough to confer the title by occupation. Means mere discovery is not enough or not sufficient to confer a title by occupation. In this case, the USA, they got that island from Spain. Spain had actually discovered the island, and USA got that from Spain, and Netherlands was contesting that the island has been subject to the sovereignty of Netherlands for a long time, and just because Spain, which discovered the island and later on handed it over to the US, does not make the island uh, occupied by the US. So the arbitrator in his award, he had judged that the island was uh, actually to go to Netherlands, and the reason was that Netherlands was continuously exercising their effective of authority or sovereignty over that particular island. So it's not just a mere occupation, but Netherlands was actually the one which was exercising its authority for a continuous period. That's why the island should go to Netherlands. So that was the adjudication in that case. So I hope that this helps you understand the two elements of a valid occupation. The territory must be terra nullius first, and second, that there must be an effective occupation. Second requirement of effective occupation in turn has two sub-elements, that is first, intention to occupy, and second, an effective, peaceful and continuous exercise of sovereign activities. So that is all about occupation. The cases that you need to remember is the Western Sahara case and the Eastern Greenland case. You can also remember the Minkiers and Akros case. You can also write about the island of Las Palmas arbitration. So these four cases should be enough for you when you're thinking about answering in your exams and from the point of understanding as well. Let's move on to the next mode of acquisition of territory. The next mode of acquisition of new territory by states is annexation. Annexation is very simple. Annexation is when a state acquires a territorial sovereignty in case of a conquest. So when a state conquers some other state or some part of territory of other state in war, after the territory has been conquered, the state then annexes the territory as part of their own state. So that is annexation. Annexation usually happens in two cases. As I told, first one is when a territory has been conquered by the state, and the second is when the state is in position of a virtual subordination. So there are two circumstances in which annexation of territory can be done. First is when you conquer a particular territory. After you conquer the territory, you annex the territory. Second is you are such in a dominant position that you can annex that territory. Now in the first case, when after you conquer a territory, you annex the territory, that again must be legal. For example, as you know, according to the 1928 Pact of Paris, war as an instrument of state policy has been declared as illegal. And you also know that when Iraq conquered Kuwait and it annexed Kuwait, it was not recognized. So this is not a recognized way of annexing or acquiring a territory anymore. So second one was annexation. The next mode of acquisition of territory is accretion. Accretion basically means sub-addition, and this occurs when new territory is added to your territory by natural causes, not because of political causes, because of war, but because of natural causes. For example, there's a volcano which erupts and which leads to generation of new land, or for example, sea levels go down, or certain geological activities lead to creation of certain land masses, something like that. So when a new territory is added mainly through natural causes to the territory which is already in the sovereignty of the state, then this is a case of accretion. The next mode of acquisition of territory is cession. Cession basically means that one state cedes its territory to the other state. Cessation may be a result of a war, or it may be a result of any other kind of negotiation. The example is cessation of Alaska by Russia to the United States in 1867. That was a case of acquisition of territory by cessation when USA acquired Alaska when Russia ceded that particular territory. Cessation can also be done by transactions like gift or sale of territory. Now, one thing that you need to know about cessation is the ceding state, means the state which is giving away the territory cannot derogate, means cannot take back, cannot demand to take back what it gave after cessation is complete. So the ceding state cannot demand that part of territory back, right? So another way of acquiring territory is cessation. The next mode of acquisition of territory is by prescription. Prescription is basically when a sovereign state exercises their sovereignty on the territory of another state for a very long period of time. And that exercise of sovereignty, which happens for a very long period of time, must be peaceful and continuous. So, if a state exercises its sovereignty over another state's territory for a very long period of time, peacefully and continuously, then they can establish their title on the territory of another state by the way of prescription. So, prescription usually requires stricter proof, and if you have to compare prescription with municipal law, you can think about prescription as something like adverse possession, where you can take possession of property property to which you have no title to for a long continuous period of time, which may be peaceful and uninterrupted. Then you may be eligible to get the title of it. Similar to that is prescription, when one state exercises their sovereignty over another state's territory for a long continuous period of time, and that should be peaceful and unobjected, then you can acquire the title of the territory by the way of prescription. Now, there are 4 requirements of a valid acquisition by the way of prescription that was given in Botswana versus Namibia case, that are very simple. First is possession must be exercised in the form of actual exercise of sovereignty. That means it is similar to the element of effective occupation that we have seen in the case of occupation. So first is that possession must be exercised in the form of actual exercise of sovereignty. The second is the possession must be peaceful and uninterrupted. There should be no objection or protest by a former state to your possession of the territory. The third is that possession must be public, means that other states must have a knowledge of it. And the fourth is that the possession must be for a long period of time for it to crystallize into a title. Okay, what I would like you to answer in the comments is tell me the difference between prescription and occupation. What is the main difference between prescription and occupation? So we'll end this class here and we'll continue with some other modes of acquisition in the next class. Thank you.